SCOTUS finally checking rogue courts? Maybe. We had oral arguments yesterday before the Supreme Court about an immigration case. The immigration case involved a defendant who'd gone through the Article II executive branch immigration courts. These are courts created by Congress specifically to handle immigration matters within Article II and take immigration authority out of the Article III courts. The immigration court went against the migrant. He appealed to the the appellate immigration court. That went against him. And when you lose at the immigration courts, there is a way to appeal to the Article III federal courts. There is a safety valve, but you cannot get to a district trial court, a federal district trial court. You appeal directly to a 3-judge panel court of appeals. This was done explicitly to make this safety valve step burdensome for the Article III courts of appeals. They don't want to spend all their time hearing immigration appeals. But this was appealed up to the Court of Appeals, and the Court of Appeals reversed the deportation order. And the grounds for reversal was they felt the immigration court had made errors in findings of fact. The person who didn't want to be deported said, hey, if you deport me, I'll be in danger in my home country. The immigration court said, I don't believe you. We're deporting you anyway. The Immigration Appeals Court said, yeah, we affirm the decision of the immigration court. And then the Court of Appeals got it and said, no, we're going to impose our own judgment of whether or not it would have been dangerous for this migrant to be deported. We think it would have, so we're going to negate the immigration court's deportation order. That's what's now appealed to the Supreme Court. And they had oral argument on this yesterday. So the tension is, how much authority are the courts of appeals going to have in this kind of dispute over the Article II immigration courts? And the fundamental question is, I think, going to come down to this. So there are two kinds of decision-making that courts generally make. They make decisions of law, right? So what laws should apply, how they should be applied to a set of facts. And then they also make findings of fact. Now, in a traditional criminal trial, the fact finding is done by a jury. But in an administrative thing like an immigration court, there is no jury. So the judge is doing both finding of law, application of law, and finding of fact. Now, normally, findings of fact are not appealable in a criminal trial because that's the province of the jury. The jury gets to decide what facts they believe are credible, proven or not proven. And that's not really appealable except in extremely egregious examples. But errors of law are made by the judge in a criminal trial, and errors of law are appealable to a court of appeals. So we have the same kind of dynamic here. We have an immigration court that applied the law to a set of facts, and the immigration court made determinations of law and determinations of fact. And that was affirmed by the immigration appellate court, and then it got appealed to the Court of Appeals. And the Court of Appeals basically said, we are going to not just review your legal decisions, we're going to review your fact-finding decisions. And the Trump administration is saying, no, that's not appropriate. Fact-finding is much as with a jury. It's not subject to appeal. That's within the province of the immigration court. And the person who doesn't want to be deported, of course, is arguing the opposite position. So that's the nature of the oral arguments here. And the oral argument is, of course, the recording of the Supreme Court. They don't have video. They only have audio. That's what we'll be listening to. It's about an hour long. And we assess the leanings of the Supreme Court in the nature of the questions that are asked by the conservatives and by the liberals, for example. That usually gives the game away. So this is all about asylum determination. So this person being deported said, no, I need asylum in the U.S. because it'll be dangerous for me if you send me back to my home nation. The lower immigration court said, I don't believe your claim of asylum. I don't believe the threat you're describing. And therefore, I'm not granting you asylum. That was affirmed by the appellate immigration court and then reversed by the Court of Appeals on a fact dispute. The question is, does the Federal Court of Appeals have the authority to engage in fact review of the immigration courts?
We'll hear argument next in case 24777, Urias-Orellana Na versus Bondi.
Thank you, Mr. Chief Justice, and may it please the court. Deciding whether undisputed facts qualifies persecution under the law involves legal interpretation, not fact-finding. Even the BIA agrees. It treats the issue as a question of law subject to de novo review. That should not change when a case reaches federal court. Indeed, the government concedes that courts must exercise independent judgment when establishing auxiliary legal principles for use in future cases. They concede that courts owe no deference in interpreting the INA's persecution standard. And courts have repeatedly established auxiliary legal principles on things like sexual violence, religious persecution, economic deprivation.
So this is for the migrant who wants the asylum. This is his lawyer speaking. I am going to slow it down because he talks fast anyway. So he's arguing that the Court of Appeals should have the authority to do its own assessment of the facts of whether the migrant will be subject to persecution if they're deported. And of course, the government, Trump's position is that immigration courts do the fact-finding, not the Court of Appeals.
And beyond. But courts did not establish those principles by pondering the term persecution in the abstract. They interpreted the law by applying the persecution standard to particular sets of undisputed facts. The government wants you to hold that de novo review applies anytime a case supposedly would make new law in some sense, but substantial evidence review when it wouldn't. There's no principled way to draw that line, and this court has never tried in similar circumstances.
So de novo review would be the appellate court looks at the facts as if no one has ever evaluated them before. A fresh look at the facts. They make their own fact-finding decisions. That's what de novo means. The standard, another standard, a higher standard would be you give substantial deference to whatever court made the initial fact-finding. And if it was a jury case, you'd give almost complete deference to the jury, unless they were objectively irrational.
For instance, de novo review applies to all fair use determinations made on undisputed facts and all antitrust determinations made on undisputed facts, not just some special subset. The government's contrary rule here would invite further confusion and collateral litigation. Better instead to just require de novo review and let judges get to judging. The courts of appeals are well equipped for the job. Several of them already have experience reviewing de novo the BIA's persecution determinations, and they generally review the analogous question whether undisputed facts demonstrate torture under the Convention Against Torture. The sky has not fallen. Under both the INA's text and U.S. Bank, courts should decide for themselves whether undisputed facts establish persecution under the law. Section 1252B explicitly provides for legal deference on closely related issues, but not this one. And decades of experience confirms that courts perform crucial legal work in applying the INA's persecution standard. Deference to the BIA is unwarranted. I welcome the court's questions.
So the BIA is the appellate immigration court. So we have, of course, federal district courts. We have Article 3 federal courts. We have the district trial courts. We have the courts of appeal. We have the Supreme Court. That's the normal structure. And those are everything except the Supreme Court's created by Congress. So the only court created by the Constitution is the Supreme Court. And then Congress creates the others. So Congress creates what are called, every court other than the Supreme Court is called an inferior court. The district trial courts and the courts of appeal. They're all in Article 3. But then we have a lot of administrative courts, like the Article 2 immigration courts, and they have a trial level function, the immigration courts, and then the appellate courts, the BIA courts that are the appeals courts or immigration matters. Those are not Article 3 courts; those are Article 2 courts that function under the executive branch. And this is Clarence Thomas.
Elias Zacharias was also a persecution case, and that was reviewed deferentially. How's this different?
Because Elias Zacharias concerned a different element of the asylum eligibility analysis. The Elias Zacharias, the disputed issue there was about the persecutor's subjective motive, their intent. That is a classic pure question of fact. And so Elias Zacharias was absolutely right to review that factual determination for substantial evidence. The statute before the court in Elias Zacharias, which was the predecessor to Section 1252, B4, also, it didn't say the asylum eligibility determination across the board. It applied only to findings of fact. And that's what this statute says as well. So we think the government is just over-reading that decision. And the government doesn't really—
I think you may be under-reading it. There was no factual dispute in that case. Everyone agreed on what the guerrillas said to the petitioner.
So this is
There was
Kagan.
no dispute about what was said or what happened. Instead, the question was whether those undisputed facts met the standard of persecution, quote, because of political opinion. So I don't see how that's not a mixed question of law and fact, and mostly a factual question.
No, Justice Sotomayor. The dispute in that case was about whether as you said, was whether the persecution was done on account of the non-citizen's political opinion or something else.
Sorry, if I said that was Kagan, I was thinking Kagan, but it's Sotomayor. And she's already challenging the migrant position here. So she's asking questions that are phrased negatively for the migrant position and favorably for Trump. Sotomayor is.
That is a question about what
But
was
there
in.
was no dispute about the facts. What was said was undisputed. And so the question was, did that meet the level of because of?
No, Justice Sotomayor. The facts of the case, what was said, what was done, as Justice Gorsuch pointed out in the earlier argument, subjective intent is something that you infer from facts on the ground. So in a murder case, you might know exactly what happened, who showed up when, who fired first. But I don't think anyone would say that the facts are undisputed in that murder case if we haven't figured out whether the defendant had the intent to kill or not. And that was the same issue in Elias Zacharias.
So what's different between what was said or done is undisputed in this case, what he was told, and the question is, did he have a fear for his life? How is that any different than what happened in Elias Zacharias?
Because that's actually not the question in this case. This is a past persecution case. Under the INA, a non-citizen is presumptively eligible for asylum if they have suffered persecution in the past. It's not this forward-looking inquiry about whether they have a well-founded fear of persecution going forward. That's a different kind of inquiry, and I agree with Your Honor that it goes to their state of mind. It involves the calculation of a future probability, and so the case for substantial evidence review would be much stronger there. But here, where the facts of what happened to my client are undisputed. The immigration judge took his testimony as credible and true, and found that the death threats he experienced were indeed credible and menacing, but nevertheless held that under the law they did not rise to the level of persecution.
So they're not really talking about the facts of the case, and of course that's a key issue here. So let me talk a little bit about the facts of this case. So this case began when the defendant here, Douglas Humberto Urias Orellano, and his wife and their child arrived in the U.S. 2021. They asked for asylum. So this is part of the Biden, tsunami of illegal migrants coming over the border. They asked for asylum. They cited repeated threats of violence from a hitman, a sicario, like the movie title, a hitman working for a drug lord in their home country of El Salvador. The migrant contended that after his half-brother, Juan, not joking, and the sicario got into an argument over a romantic relationship between their parents, the sicario shot Juan and another of his half-brothers and then tracked the defendant, the migrant here, across the country, repeatedly demanding money and once hitting him 3 times in the chest. Under INA law, Immigration and Nationality Act, individuals can qualify for asylum if they fled their country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership, or a particular social group or political opinion. So here, the migrant is arguing that he qualifies for asylum not from race or religion or nationality, but because of membership in a particular social group. His family he wants to find as a particular social group, threatening any part of his family, therefore would be persecution of him as an individual. And the immigration judge at the Article 2 Executive Branch immigration judge denied asylum, said that the sum of the threats and the one time where this migrant was hit 3 times in the chest does not rise to the level of past persecution. So we're dealing with several levels of things here, right? First is the factual claim. Is the factual claim in dispute? This guy, the migrant, says, hey, I was hit 3 times in the chest on one occasion by this hitman. Nobody's disputing that. In theory, it could be a dispute, right? In theory, you could have the hitman there saying, I never hit this guy in the chest. And you would have a factual dispute, and the court would have to decide who to believe and not believe. That's not what's happening here. The immigration court said, I'm not disputing your claim. I will accept your claim that you were hit 3 times in the chest, but even if that's undisputed fact, it still does not rise to the level of persecution that would warrant you receiving asylum. So I'm denying you asylum. And when that was appealed, he was denied asylum on appeal. And that's the facts that were presented to the Court of Appeals. The Court of Appeals said, no, we think those facts do amount to persecution, and therefore we're going to overturn the decision of the immigration court.